10 p.m. Good afternoon. And yes, you're still listening to Hard Facts on 93.3 Nigeria Info. I am yours truly, Kadakuru Batabo. Now, we want to switch back to politics for a bit. We've got, about 35 minutes to try to, or even 30 minutes to try to have the conversation we're about to have right now. So I'm going to race against time and run as quickly as possible. Yesterday, it was in the news. RISIEC came out and said that no court order can prevent the commission from conducting party primaries and elections. Now, RISIEC chairperson or chairman is a retired justice. I want to believe is very much in the know of the several laws that has to do with electoral activities in Rivers State. And by the way, we're live on Facebook, we're live on YouTube, and we're active on X Nigeria Info PH. Joining me to have the conversation is a lawyer, a socio-political commentator, Living Jamala Esquire. Living Jamala, it's good to have you in the studio. I'm sorry I keep calling you out, but the issues keep coming. Welcome on the show.
Thank you, Kalada. I think you need not apologize. It's one of the services to humanity.
All right.
The little way we can when the opportunity is given.
Okay, so what do you make of Justice Enebeli retired's statement? No court order. Is that the reality?
Kalada, I'm so elated that at least from my limited knowledge of the law, I have a revered justice of the Rivers State High Court who has come out to buttress, somehow, relieve me of my emotional biases, if some persons will look at it that way, justifying my position all this while that the true position of the law, which we know, and for now there is no superior argument whether as a decision of court has been made, is the fact that the provisions of the law with respect to regulations guiding the conduct of election oust the jurisdiction of court from preventing even the political parties from conducting their own primaries, not to talk of the main election. I've always held the view that for whatever reasons that the election will not be conducted, it is not because of an order of court, but maybe an in-house arrangement of the Rivers State Independent Electoral Commission.
If I understand you clearly, you're saying that a court cannot stop INEC from conducting elections.
A court cannot stop INEC from carrying out its constitutional responsibility.
So what if INEC did not follow due process? Can a court say, for the fact that you have not followed the law, I am stopping you from going on with the process?
If INEC failed to follow the procedure as stipulated also by law, the court will not stop INEC from conducting an election, but rather the court will nullify that process, having failed to carry out that process in accordance with the stipulated provisions of the law. There are two different things. Stopping you from carrying out a constitutional responsibility is different from interpreting whether that constitutional responsibilities was carried out in accordance with the provisions of the law.
Now, it's all lexicon, vocabularies, and all of that. But now, in the context that we are looking at it from,
Yes.
if the court nullifies the process, the court can be said to have stopped the election.
The court has not stopped the election in my own understanding. We have some situations where governors were elected upon the conduct of an election. And the court looked at the procedure and somehow disagreed with the umpire and said, you never conducted the election in accordance with the laid down rules as provided by the Constitution and even your own guidelines. And therefore ordered the umpire to reconduct that election.
Okay.
So it is different from preventing you from doing a particular responsibility saddled by law.
Okay. Now, let me come here. So the people who have gone to court, are you saying they went to court too early, that they would have allowed the elections to hold before going to court to prove that due process was not followed? Because you're saying it cannot stop, but it can ask the election to be redone.
Yes, the matter pending before now, the matter pending now, which is at the stage of judgment, any day we could be called upon to hear, is the fact that they are asking that some certain procedures were never taken by RISIEC.
Mm-hmm.
And if the court agrees with them, assuming this judgment is to come after the conduct of the election, and if the court agrees that, yes, certain procedures were supposed to be taken by RISIEC, and they never took those steps, the worst the court will do in the circumstances is to nullify the process, which is far be from it, from my own understanding.
Okay. So when Justice Enebeli retired, said no court can prevent the commission from conducting party primaries and elections, and backed it up by citing Section 60, subsection 2 of the Rivers State Independent Electoral Commission Law 2018, what was he really referring to?
It was emphatically stating the position of the law with respect to the conduct of Rivers State Local Government Election Commission. The Electoral Act.
You do have the local government.
This is the local government law. It's different from the act, from the law creating RISIEC.
Okay.
Yes. Now, if you look at...
Okay.
Yes, there are two different laws. Local government law of number 5 is different from the law establishing the Rivers State Independent Electoral Commission. Even in the Electoral Act, the Electoral Act made it so clear, unambiguously, that the court lacks the jurisdiction to prevent the holding of a political party's primaries and the election. It is just, I think, the laws were somehow imported from the provisions of the Electoral Act, replicating same in the Rivers State law establishing RISIEC. And therefore, all the actions of RISIEC taken so far, whether it is right or wrong, a court of law lacks the jurisdiction to stop an institution of government established by law from conducting its activities. It's like someone going to court asking that the court should stop itself from adjudicating over affairs brought before it. You cannot, by an instrument of whatever, prevent an institution of government from carrying out its statutory responsibility. That is the law, and it is elementary. I believe those who are somehow before the court are doing so for the sake of political grounds, not that they are not aware of these laws.
All right, let's listen to what Justice Enebeli had to say yesterday.
Section 60, subsection 2 of the Rivers State Independent Electoral Law of 2018. It is provided that no court proceeding shall restrain primaries or the conduct of elections. Where it is there. There is no judgment as at yet perpetually restraining us from conducting elections. No judgment. And the Supreme Court of the land said we should conduct elections. So Rivers State, even the federal government is enthusiastically expecting elections to be conducted. And so 5th October 2024, that's it. By the grace of God, it's as invariable as it is sacrosanct.
Okay, all right. Does the judgment on Friday have any sort of effect on what is happening as it relates to local government elections in Rivers State, given some people are interpreting that judgment to mean, something about it being status bad, if I'm correct, but some people are interpreting it to mean that Martin Ameole and the others have been recognized, and if they are indeed recognized, does it not mean that the local government law has been amended? And if it has been amended, does it not mean that certain processes have not been followed?
It is somehow embarrassing to hear that some legal minds, those who are trained to understand the rudiments of the law, will come out to say that the ruling as given by my Lord Justice Lifu of the Federal High Court sitting in Abuja has anything to do with local government election in Rivers.
No, I'm the one connecting it. I've not said anybody. Some people say it gives credence to Martin Ameole and the others. But I'm also now saying that they have amended the local government law, right? And if they have, then can we argue that certain processes were not followed if we agree to the argument that they are now recognized as the legitimate lawmakers?
Canada, we have had the privilege of discussing whether or not the Amewule-led assembly in creating the law, local government law number 2, 2024, whether that law, I know they vetoed the powers of the governor by because the governor never assented to it, so they vetoed it, and in the eyes of the law, it was presumed that that law is inexistent. But remember that particular law was brought before my Lord Honorable Justice Kyo, sitting in Port Harcourt, River State High Court, Port Harcourt Division, and that law has been set aside. I'm aware that there is an appeal before it, but there is no contrary decision taken by the Court of Appeal as it stands. And therefore, we have held position that the preparations for the conduct of the October 5th election is hinged on the law of River State Local Government Law number 5 of 2018. And so we do not want to even presume that that law number 2 exists until a superior order of court is given affirming that law. So as we stand now, from our own understanding, the River State, the RISIEC is conducting its affairs based on the 2018 local government law. And if they have, like Section 5 made it clear for them, they have in that exercise of the powers brought out guidelines. And it is their guidelines, like we are also made to understand, with some little modifications due to some events that happened, that they are following. So I do not see anything contrary to the activities of RISIEC. And the judgment of my Lord Lifu, there is no bearing that has to do with the local government election. It has not even validated the legal grounds as to the Amewule's faction. It talks about being statute barred. The matter is existing before that court. Allow those courts to do. Whether my Lord was right or not into admitting or holding that it is a pre-election matter. Canada, I will refer you to Section 285 of the 1999 Constitution, subsection 14, that talks about what qualifies to be political pre-election matters. And there are 3 categories, as also stated by the Supreme Court in APC against Dele Moses, and several Ibrahim Umar of 2019, APC against Dele Moses of 2021. So it is very, very far. Why that matter is pending at the Court of Appeal, I will somehow free myself from diving into the merit of that case. But whatever the court, as presided by my Lord Lifu, has held, is far from the reality that asking questions as to whether or not defection of members of the House of Assembly is in line with Section 109, subsection 1G and 2 of the Constitution, has to do with a pre-election matter, is very, very far from it.
Okay, now let's also look at something else. The RISIEC chairman did say that the Supreme Court has mandated states to conduct local government elections. Does that mandate surpass any judgment from a high court?
Yes,
in terms of order to stop elections?
The Supreme Court, we have held a position that no court has the jurisdiction to stop the holding of an election, whether local government, national election is circumstance. Now, the Supreme Court, by their decision as to whether or not local government autonomy should be exercised, reading Section 7 of the 1999 Constitution, said every local government ought to be manned by a democratically elected government. And by that understanding, states were mandated. In fact, they were not even mandated. Okay, by the interpretation of that judgment.
I would have to beg you. We have to go for a commercial. When we come back, we'll continue from where you have stopped.
Thank you.
You are tuned in to
Nigeria Info. We'll be right back.
just joining, you're welcome. Better late than never. We're looking at the statement of the RISIEC chairperson or chairman in person of retired Justice Adolphus Enebili, who has come out to say no court order can prevent the commission from conducting party primaries. That means that he is looking at holding or conducting the local government election no matter what the hurdle is, conducting it on the 5th of October 2024. Now, he cited Section 60, subsection 2 of the Rivers State Independent Electoral Commission Law of 2018. Now, we're looking at the possible loopholes to that statement, the possible loopholes of that statement. Currently, my guest is saying there are no loopholes and that no court can stop. And he cited the Electoral Act. He has cited also, he has agreed with Section 60, subsection 2 of the Rivers State Independent Electoral Commission Law of 2018. But I asked the questions before the break. I will get his answer, but take a listen to Justice Enebili.
Section 60, subsection 2 of the Rivers State Independent Electoral Law of 2018. It is provided that no court proceeding shall restrain primaries or the conduct of elections. Well, it is there. There is no judgment as at yet perpetually restraining us from conducting elections. No judgment. And the Supreme Court of the land say we should conduct elections. So, Rivers State people, even the federal government is enthusiastically expecting elections to be conducted. And so, 5th October 2024, that date, by the grace of God, is as available as it is sacrosanct.
All right, so my guest will continue in a bit, but let's quickly take a look at the headline news.
News, Nigeria Info on
92.3.
Headline News.
Now, the headline news. Election observers worried over RISIEC's lack of preparation for 5th October local government election. Lawyers expressed different opinions on APC Tony Okocha's right to stop conduct of Rivers LG election. Rivers State Information Commissioner Defense setting up a flood prevention and management committee. Federal government gives date for implementation of new minimum wage. On the foreign scene, several persons arrested after death of a woman inside port. Details in the 6 p.m. news bulletin. To reach the news team, send an SMS or WhatsApp to 0808 721 7215. I am Kalada Kurubatubo. Do stay tuned.
Business,
Agriculture, politics,
entertainment,
health, education. We talk about everything.
We are 92.3 Nigeria Info.
This is Hard Facts.
All right, 5:31 p.m. Living Jamala still in the studio. You're listening to Hard Facts in 92.3 Nigeria Info. I am Kalada Kurubatubo. And just before the break, I threw a question at Living Jamala Esquire as to, the legal implications. The Supreme Court has given a declaration on mandated states where there are no local government administrators elected democratically to conduct elections. Can a lower courts give an order restraining the State Electoral Commission, from that angle, from that perspective, from holding elections? So you had, before I read the headline news, you had Justice Enebili saying, we've been mandated to hold elections, so we're going to hold elections.
Yes.
So can a state or high court, federal state, anyone, stop, giving that Tony Okocha is in court?
Tony Okocha is in court, and we had the privilege of reading the reliefs that is sought for in the Federal High Court sitting in Abuja, and we are also made to understand that the ex parte order gotten by Tony Okocha somehow extended by the court is not also preventing the holding of the election. The court is rightfully aware of that fact. But rather, what the court did is preventing some particular institutions of government from relating with RISIEC. Now, we have also looked at Section 15 of the Electoral Act 2022 that talks about the voters register. We have also looked at Section 4 of the Nigerian Police Act that talks about the responsibilities of the police with respect to security of lives and property. And so, if that order of court is to be taken hook, line, and sinker, then we are asking the police from refusing to obey the provisions of Section 4 of the Police Act. It is clear, no one is doubting the fact that the court lacks the jurisdiction from stopping the holding of election. That is why the court never entered that ruling ex parte in favor of the prayers of the applicant, rather modified that prayer of the applicant to restrain some institutions of government. Kalada, that order never prevented or stopped the holding of the election.
Right.
And we have agreed in this studio that yes, we can do away with those institutions of government.
All right, let's take a listen to what Justice Adolphus and Enabili said about, Section 15 of the Electoral Act that you just mentioned.
On the 11th of July, the Supreme Court of this nation laid it down emphatically, compendiously in judgment that democratically elected local government elections should be conducted in all the states that have not done so. And the consequences will follow if we do not. That is it. Section 15 of the Electoral Act 20 as amended. Look at it there. INEC has a responsibility to give states RISIEC voter system.
So do you think INEC would go with what is in the Electoral Act, or INEC would go with the order of court?
Yes, for whatever a decision of court is, no matter how negatively interpreted, it must be set aside, and therefore you have to obey it until
even
it is set
if
aside.
it is
It is clear that order of court was given without recourse to Section 15 of the Electoral Act. And so it behooves on the respondent here in the circumstance being RISIEC to apply for the setting aside of that order.
But would INEC not be defaulting or flouting the Constitution if it fails to do what, or not the Constitution now, the Electoral Act, if it fails to do what is written in the laws that guides its operations?
One of the excuses that an institution of government can be somehow reasoned with respect to carrying out a particular function placed on it by statutes is to the effect that a court of law has placed a bar on it. And so, for whether or not that decision of court was right, it must be obeyed, no matter how stupid that ruling is. It must be obeyed until set aside by a superior court of record. And so, while yes, we agree that Section 15 has made it mandatory for the National Electoral Commission to provide the register to states, to state election commissions and other bodies as provided for under the law. But there is a bar so far placed by law. The interpretation of the law is that whatever the court decides at that particular moment, Oliver Wanden Holmes' definition of what law is that whatever the law decides at that moment is the true definition of that position of the law.
Are you saying the courts are bigger than the because you lawyers, you legal representatives, you in the judiciary, you tell us there is nothing bigger than the Constitution.
The ground norm is the Constitution.
So is the court bigger than the Constitution?
It is the interpretation given by the court with respect to every provisions of the Constitution that stands to be the law until set aside by a superior court. And therefore, I am saying that yes, Section 15 of the Electoral Act places the responsibility on INEC to make this register available to RISIEC. But since a court of law has barred the production of that document, RISIEC has a responsibility. If it wants to rely on that same register, then RISIEC has a responsibility of setting aside, applying to a higher court of record to set aside. I have given the advice pro bono to RISIEC. Section 5 of their law, Rivers State Local Government Law, gave them the powers to set out modalities. And for the fact that a court of law has prevented RISIEC from giving them the voters register, it's not a bar from them to conduct the election, and they must not rely on the said register to conduct a local government election.
The police. So, or major responsibility, I wouldn't say so, wrong of me, but major responsibility, protect lives and property.
The responsibility of the police, Kalada, you remember in this studio, we talked about Section 4 of the Nigerian Police Act. I talked about the protection of life and property, the sole responsibility of the Nigerian police. Yes, the court has said, do not relate with RISIEC. And I gave the illustration. If the Nigerian police were to be passing around on the 5th of October and a crime is being committed by an individual, will it prevent the police from carrying out its statutory responsibilities? I do not think so. And therefore, and if also, remember I told you, if the citizens of Rivers State can guarantee RISIEC that on the day of the said election we're going to be peaceful, what then prevents RISIEC from conducting the election without the active participation of the Nigerian police?
But there are people who are on the other side who do not want the election.
Section 4 of the Nigerian Police Act will come into effect, mandating it will be a dereliction of duty for the police to look the other way while a crime is being committed.
Can the police argue that there is the proclivity, the tendency of violence being perpetrated, and for that reason, just like they have done with the secretariats, say no elections? Does the police have that authority?
The unholy part of that secretariat is the fact that there is no clear provisions of the law stating so, and they hide under the cover of somehow assuming that there's going to be violence if they are opening the door. But in the circumstance of the local government election or election generally, the law gives the Nigerian police to provide security for all and sundry.
But there's now you've just said there is a court order, and the court order must be set aside or it becomes law because it is an interpretation of the law.
Yes, I say so. With respect to RISIEC getting the register, although there is a clear provision
there's also
as to the mandatoriness of INEC from supplying the register.
But there's also the issue of the police not providing security. So if the police would stand on that order, do you think they can then argue that this is likely to there's a way to put it, is likely to cause a breach
of law and order?
I think I'm beginning to speak like them. It's likely to cause a breach of law and order, and for that reason, they would say usually the protest should not hold, but in this case the election should not hold. The
constitutional responsibilities placed on the Nigerian security agencies is far different from that as placed by INEC. There are some essential organizations, institutions of government that do not embark on strike, do not embark on unionism, even as provided for by the Labour Act. Nigerian police is one of them.
So when you say,
therefore they have essential responsibilities to provide.
But no. Sorry, I want to pause you, Barrister Jamala. And the reason I'm pausing you is because you've just said no court can stop INEC from conducting. So that means they're, whenever it's election time, are on essential duty or duties. Same with the police. You've said it is mandatory for them to protect
under Section 4
lives and properties and to ensure that there is peace and order in society. And I'm now asking, is there any, because it looks like both sides have got essential duties on their hands. So can we then argue that if INEC has to obey the law, then that means the police should also obey the law? But this time, they can argue and say, hey, let's not hold election because it's going to turn into a war. I don't know if I'm making sense. I'm not a lawyer. I'm just asking the questions.
Under the Electoral Act and even the Constitution, I'm assuming we are operating like a national election.
Okay.
It is the president that has a responsibility to decide whether or not the situation the country found itself is practically impossible for the conduct of election. Now, the police is so different in the circumstance that we cannot equate it with INEC. The responsibility of the police is a minute per minute affair. In fact, it is a second per second affair. Unlike the periodic activities of INEC, police is saddled with the responsibilities of providing security for lives and properties of the citizens of the Federal Republic of Nigeria. And their actions cannot also be stopped by a court of law. And I said, remember the other expertise got in. It's to the extent that do not relate with RISIEC. Not that you should not relate with Rivers Indigenes. Not that you should not relate on that day with the geographical spread of Rivers State. Do not relate with RISIEC.
All right.
It will not stop the area command in Choba from carrying out its responsibilities on the 5th of April.
Okay.
Or of October. It will not stop the commission, the headquarters, the first headquarters of Rivers State Command from carrying out its activities on the 5th of October.
Okay.
But they said, please limit your relationship with RISIEC on the 5th of October.
Okay. I want to come in now, and I want us to go back briefly to the House of Assembly saga. Does the House of Assembly have any role in how RISIEC functions? You know, do they have any oversight function? Or is it solely the responsibility of the executive to determine how, RISIEC operates and how it's funded?
The truth is, the law establishing RISIEC is a creation of the law made by the Rivers State House of Assembly. And therefore, somehow they have oversight functions over the activities of RISIEC if the need arises. So you cannot say the Rivers State House of Assembly do not have some.
I asked the question.
No, they have. They truly have oversight functions over the activities of RISIEC where the need arises.
All right, we've got to go. I've been signaled. The reason why I asked that question was to also know if the Martin Ameule led assembly could, have any kind of impact on the forthcoming election, given the arguments as to
the question. The answer will be very simple. Whether in the eyes of the law, the Ameule's led assembly is recognized.
All right, the argument still subsists, but I've got to go for now. There is a commercial to stay tuned. And I thank you, Barrister Jamala.
Thank you.